Welcome. Welcome to Bold Women Lawyers Spotlight, where we talk about everything related to running a solo and small law firm. I am excited today by our guest, Katherine Taylor. Katherine is a business lawyer. Katherine is my business lawyer. She was my business lawyer for my law firm. She's my business lawyer for Bold Women Lawyers. She's my go-to person for every question I have about legal stuff relating to my business, because as a lawyer, I had my specialty area. It was not business law. So, Katherine, welcome. We're really glad to have you here today. And I want to jump right in. So can you just tell us a little bit about yourself and your law firm and what you do?
Absolutely. Well, I've been in practice for probably over 25 years. And the first part of my career was with a larger law firm handling business and commercial litigation. And then I spent about 10 years with a local government attorney's office, which is basically in-house counsel for that county. And I started my own practice about 15 years ago, and have since that time represented small businesses and small business owners in a variety of business related legal matters. And that's essentially my specialty now.
Okay. All right, great. Now, I know myself as a business owner, I have lots of questions about legalities affecting the business. And as I said, that was not my area of expertise, which is why I have you as my business lawyer. But I know an issue and a question that I had and that I am asked a lot about is the idea of I'm building a team. Are they employees? Are they independent contractors? And now we throw in that people are remote workers. How does that affect things? So tell us, Katherine, what's the difference between employees and independent contractors? And what are the implications of each for the business owner?
So sometimes the differences are hard to see from somebody like, a business owner. And, but the ramifications can be significant. And so it's important to understand what those differences are to make sure you classify your workers properly. So the first couple things I like to tell people, and I kind of say this in a joking manner, is 1099 is not a verb. What do I mean by that? So, you've probably heard tons of people say, oh, I'm just going to 1099 her. I'm just going to 1099 him. Yeah. And so that kind of goes into my next comment, and that is that it's not really a choice necessarily that the business owner makes. So in other words, if you have a worker who really should be classified as an employee based upon certain factors, which I'll get to, you don't really get to choose. You don't get to say, I'd really rather them be an independent contractor because frankly, it's easier. You don't get to make that choice if in fact, all the factors show that they should be classified as an employee. So where it gets difficult, however, is that classification and the factors that are looked at are different for different government agencies. So for instance, who are the government agencies that would be concerned about whether a person is an employee or an independent contractor? First, you've got the IRS. Interestingly, the IRS really is more lenient with regard to that classification than a lot of the state agencies are. Because the IRS, and think of it this way, the IRS is concerned about tax, right? Income tax. So in some respects, whether that person is an employee or an independent contractor, in some way, shape, or form, the IRS is going to be getting income tax from that person. Now, it's going to differ, if it's an employer versus an independent contractor, because there are going to be different employment taxes that are paid by the various people. But in essence, the IRS definition or the factors that are looked at are much more lenient. So you could have a person who, let's say, you've decided for whatever reason you believe that they fit the definition of an independent contractor for IRS purposes. That may well be. But then if one of the state agencies, I practice in Maryland, and many of the state agencies are similar, all over the country. The two interests, I guess, the state agencies have are unemployment insurance and workers' comp. So what are the interests that those agencies have? They want to make sure that people, whether they're classified as an independent contractor or an employee, are covered if they have an on-the-job injury by workers' comp, or if they get fired or lose their job, they get unemployment. So in Maryland, especially, the agencies that essentially manage the unemployment and the workers' comp, they're two different agencies in Maryland, look at that classification much more strictly than the IRS does. So for instance, you could have a person who's been classified as an independent contractor, and let's say that person gets fired, and or you cancel the contract, right? So if they're an independent contractor, you just cancel the contract, and maybe they kind of felt like they were an employee, so they go and file an unemployment claim, and then the unemployment commission comes to you, Sharon, owner of Bold Women Lawyers, and says, oh, so and so filed an unemployment claim. You're like, no. She's an independent contractor, not an employee. So the unemployment commission is going to ask you for some more information, and perhaps based on the information they get, classify for that purpose that person as an employee, and basically say, not only do you need to cover, this unemployment claim, but you maybe assess penalties going back because you never paid in at the beginning.
So if so if I say, oh, I'm going to 1099 you,
right,
and that's what I do, and then I end my contract, and the unemployment commission comes to me and they say, now you're going to have to cover it. Does that mean that I have to pay out of my pocket what they're being paid for unemployment?
What that would mean is that you would have to pay the unemployment, insurance, the payment.
Okay.
And of course, when, and I don't know, it really depends on your business and whatnot as to how much that would be. But even worse than that, there could be penalties and interest. And then if in fact that agency is doing an audit, and I've had a number of clients that have gotten audited by these state agencies, they could go back and find maybe other workers that should be, reclassified. And then, so the penalties and the prior costs of the insurance that you hadn't been paying could add up.
And at least in Maryland, I know that the unemployment commission, they will determine what your rate is that you have to pay. So let's say I had employed this person and I 1099 her for, let's say 2 years.
Right.
And then the unemployment says, she was an employee. Will I then be responsible for those 2 years worth of unemployment insurance payments that I should have been making?
Probably. And
then plus penalties and
interest, right.
Ooh,
yeah.
So that can add up.
Right.
That can,
right.
yeah. Okay.
Now, here's the thing. Generally, these state agencies and even the IRS, the IRS, might do like random audits. For the most part, these state agencies are much more complaint driven. So for instance, if somebody doesn't file that claim, the workers' comp or the unemployment insurance claim, probably 49 times out of 50, you're not going to necessarily be looked at. So the risk is not necessarily all that high that you're going to get caught. But if you do get caught, then, it can be, at a minimum, tons of time. Yeah. And then it could cost a lot.
Well, and we're lawyers, and so we're risk averse. And
Absolutely.
Do you honestly want to take that chance? No, I know I don't. Yeah.
Right.
Okay.
Right.
So how do we know? I want to hire a legal assistant, say, or a paralegal. And I'm thinking, it'd be better for me if I could 1099 him or her. How do I know the difference?
So here's the thing. The general factors that are looked at, well, the factors that are looked at by the IRS, let's say, are also looked at by these other agencies, okay? But in addition, there are factors that are looked at by these agencies that aren't necessarily looked at by the IRS. So what are those main factors? Supervision, control over the person's schedule, control over the person's work hours, who provides the equipment, who provides the the supplies necessary for that person to do their job. To the extent that you don't have the right to control the work that the person does, they're going to be much more inclined to be classified as an independent contractor. It's interesting, though, as lawyers, when you think about it, we not only have a legal, a business, but we have an ethical obligation to make sure the people working on our cases with our clients are supervised, right?
Right.
So, in many situations, it would be much more difficult, I think, for a lawyer to say, well, I don't really have any control over that person's work, because you, as the lawyer, are responsible for everything that gets done for that client, as opposed to maybe like a retail shop, or something like that, where there's no ethical obligation. So that's one of the factors, control, provision of services, equipment, control over schedule. Like if you say to somebody, you have to be available these hours, and this is the work that you're doing, you have to use my equipment, our software, you have to log in with these passwords and all that, then it could be much more closer to being an employee. It probably would be classified as an employee. But let's even take a paralegal. Let's say there's a paralegal, and we're in the online age now. I mean, there are tons of services out there,
right?
Where
freelancers, right? There's plenty of freelancers,
absolutely.
yeah.
So if you in fact have, let's say you hire, or you contract with a freelance paralegal, if that person is also doing work for other lawyers, and bills you, an invoice, sends an invoice to you, and you don't tell them when they're going to work, let's say that I'm just trying to think of something that would not necessarily require supervision, a whole lot of supervision. Let's say,
I was thinking from my practice, if I hired a paralegal and I said, I need you 10 hours a week, and I need you to get medical records for me and organize them. Right. I'll tell you what to get, but you go and do it and get it organized, and 10 hours a week.
Exactly. So that might be an arrangement that could be an independent contractor versus an employee, because you're not telling them who to call, how to set up the binders, that sort of thing. But going back to your question, how do we know? It's really tough. I've counseled a lot of clients who really want to go the independent contractor route, and then ultimately decide, what, it's just too much of a gray area, and I'm going to be safe rather than sorry, so I can sleep at night, and just classify the person as an employee. I'm actually seeing that more and more. And I think that's because the IRS, but also a lot of the state agencies that kind of govern workers, are really starting to take a look at various industries. One of the industries that I believe is being looked at a lot is the mental health practice industry, which is historically been based on this independent contractor type of model. And I've got several clients who are mental health practitioners with practices who have converted their independent contractors to employees because there's been questions raised by one of the state agencies.
That raises a question to me too about, what about lawyers? You're a solo practitioner and you need help
Right.
But you don't need, an attorney full-time. You're really not that interested in bringing on an associate
Right.
in the traditional way we think of associates, but you need a lawyer to do
Right.
some of your work.
Right.
How does that work?
So I'll tell you how I do it, because I have a couple of lawyers who work with me who are not employees. So one of them has essentially her own practice, and she takes work within her practice, but she also takes work from my practice. And now, so I don't control the work that she does. I don't require her to, run letters by me, and she has her own malpractice insurance, and she's an experienced attorney. And so she can really operate essentially on her own independently. So that's one. So I think that another situation could be, let's say I hired a new lawyer. And I said, you know what, I just want to treat you as an independent contractor. But that person, being new, really needs my supervision. And ethically, I have to provide that supervision, or else I'd be committing malpractice if I let that lawyer go out and do things, for clients and perhaps mess things up. So that person really should be classified as an employee, even if they don't want to. It's not really even up to them. If that same person is, doing project work for a number of different lawyers, let's say, it might be a little different if they have their own business set up. One of the factors that's looked at, and there's just this long list of factors, but one of the factors is this: does the work for your firm, is that pretty much that person's sole source of income? Okay. So if I hire a lawyer who's working 20, 30 hours for me, and that's really the only job she has, right? And all other factors being the same, as opposed to somebody who works maybe 5 to 10 hours a week on the work that I have, but also does this work for other people, then, the money that I'm paying that lawyer isn't their only source of income. And that's only one of the factors that's looked at.
Yeah, I can see that because, because there was actually a time when I was initially learning disability law that I had my own firm, but I was also doing work for another disability lawyer, handling hearings,
Right.
As an independent contractor, and I learned that end of the business, but I had my own firm with other cases, et cetera, going on.
Right.
Now that's interesting, because there are a lot of lawyers now, and may have been for a long time, but whose practice is based in large part on handling overflow in specific areas of law from other lawyers, that they know. Or I was talking to somebody yesterday who does appellate work. She does nothing but appellate work for other lawyers.
Got it.
So, writing the briefs, and obviously she's not supervised doing that, but she has a number of lawyers, that send her work.
Right.
So, and she has her own independent business.
Right.
But that is the nature of the business, is doing work for other lawyers as a consultant or a contractor to other law firms.
And that sort of situation, and certainly with appellate work, is, many times lawyers who do appellate work, in some respects, that's like a project that can be separated from, other work that from even the underlying trial case. It's like its own separate project, so to speak. But yes, if you've got a lawyer doing appellate work for a number of different lawyers, and he or she has their own business doing that, they've probably got their own entity set up, their own malpractice insurance. And so it's much more likely, yes, I think that would be more of a consultant or contractor kind of arrangement. So
if you have somebody who, you determine, I guess this is going to have to be an employee. Okay, then obviously if it's a lawyer, obviously that implicates malpractice because you'll need to cover them, right?
Correct. Right.
Okay.
Yeah.
What about other benefits? Is there, from a business lawyer point of view, are there other benefits that you would need to provide depending on the number of hours they work?
Absolutely.
How does that work?
A lot of times it doesn't even depend on the hours because most of the laws relating to, our wage and hour laws really don't necessarily require any certain number of hours to be worked in order for them to be in effect. For instance, under the Wage and Hours Law, the Fair Labor Standards Act, you have to pay overtime over 40 hours. If a person is making a salary, you have to make sure that the hours that they work based upon what they make, on a weekly or monthly basis, at least add up to minimum wage, which for a lawyer, most of the time it's going to. But that whole overtime issue could be a difficult one. But if they work over 40 hours and you're required to pay overtime.
But is that even if they were salaried?
No, so there are exceptions, and I'm not a wage and hour lawyer.
No,
however,
understood. Yeah.
Right. There are definitely exemptions. So you can have an exempt employee that doesn't have to be paid overtime, but the person has to be paid a certain amount per year in salary in order to be exempt. There's some other factors that are looked at to determine whether the person's exempt. They typically have to have either doing professional work or have some sort of like management responsibility. Mm-hmm. And again, a lawyer is generally going to be paid enough on a salary basis to reach that threshold. I think it's like 34,000 or something a year. But you could see, for instance, where let's say you hired a receptionist, mm-hmm. And you wanted to somehow classify that person as exempt. If they're not making 30-something thousand a year, and if they don't have any sort of management responsibilities, they're not exempt, and they have to be paid overtime.
Right.
And then in addition to the overtime, there's the fact that if you have a retirement plan, or 401k, or a simple, or a SEP, or whatever it is for your business, then you have to, employees have to be eligible after a certain period of time. It depends on what the plan states, but generally it's no more than 3 years. So after a certain period of time, then that employee is going to be eligible to participate in that retirement plan, and you as the employer have to allow them to be able to participate. Mm-hmm. If you have, certainly there's sick leave that has to be, in Maryland, there's a Sick and Safe Leave Act, which is kind of an add-on to federal law, and that has to be complied with when you have an employee. Mm-hmm. So there are all these different sets of laws out there that all have different policy reasons behind them, and therefore look at that classification a little differently.
So on the retirement plan issue, they have to be able to participate. Now, do you have to contribute to that as an employer, or could it be a plan where they're eligible to participate, but it's up to them how much money they put in?
Right. So here's the deal with a small business owner. I think that you can have plans that don't have mandatory matching, but you can't match yourself if you don't match your employees.
Okay.
And most business owners want to maximize the amount that they can put in to their own plan. And so, you're going to have some matching for yourself, but you can't treat those employees differently. And that is under the ERISA laws, which is federal laws. Right.
But that can become a real issue for a small business, because then you're taking that into account as you factor in, well, what salary can I pay? Correct. And am I still at a competitive rate?
Right.
Especially in the current environment where, where it can be difficult to find qualified help and good team members. So particularly for a small business, like a small law firm, a solo law firm, that can be difficult because
can.
numbers don't always add up. Yeah.
Exactly. Plus you've got, when you pay an independent contractor, the employer, and I'm using that in air quotes, the person that is paying the worker isn't required to pay employment taxes because it's just a contract.
Right.
But when you have an employee, and so it's the independent contractor is required to pay, they're considered to be self-employed, and they have to pay the employer and employee share of employment taxes. When you have an employee, the employer is required to pay the employer's share,
Right.
which is like 7.5%, but you're also required to do the proper withholding every 2 weeks, and pay and make sure that you have a proper payroll process in place to do the withholding. And that costs money. You're either paying your own payroll person to do it, or you're paying a third party to do it. And yes, it really increases the cost of having an employee.
It does. And I think, myself, as a small business owner in my law firm, and I had employees, and I was so tempted to say, do you understand that I am paying 7.5%?
Exactly.
But I held back because,
Sure.
well, of course I'm paying, because that's what employers do in this country. You match that 7.5%. But as an employer, you're ticking off in your head, well, I'm paying your salary, and then there's, the payroll taxes, and then there's the unemployment tax, and then, if I want to be competitive, I need a retirement plan. But now, I'm limited as to what I can do. Yeah.
And any benefit
challenge.
Any benefits? I mean, the Employees Retirement and Income Security Act, ERISA, went into effect. I think it was like in the early to mid 80s, maybe even before that, which really kind of changed the total landscape of fringe benefits for employers. Because basically what ERISA says, in overall is you've got to treat employees fairly. You can't have your executives, funneling all the benefits to the higher paid executives, and then, the lower wage employees not having any benefits. They have to be pretty much equal. I mean, there are lots of ways that companies can go around that. They can bonus the executives extra salary, but in general, if you have a health plan, everybody has to be eligible to be covered. You can't say, well, if you're part-time, you're not covered. And I think that there are some, I think that there are some hourly thresholds, which below which employers aren't required, for instance, provide health insurance. But I'm not sure what those are. But in general, if you've got, especially full-time employees, they all have to be eligible after a certain period of time. Again, that all has to fall within whatever the plan is.
Yeah. And that, and again, that can become costly depending on, what type of plan you're offering, and how much are you going to contribute versus how much will the employee contribute, and is it competitive, or can you, it's tricky. It's all tricky.
It can also be a disincentive for the owner of the business to provide that, that benefit.
Yes.
Because it is costly. And so let's say say with my business, I decide I want to have employer-sponsored health insurance for whatever reason. Then I'm going to have to make sure my employees are also eligible to participate. Whereas, I could just go out and say, well, I'm just going to cover myself on the open market and not, provide it as a benefit.
It's a benefit. Right. The other sort of dirty little secret about that is if you're going to offer health insurance, and I mean, I did, and what I found out was it can be a big disincentive to hiring an older worker.
Wow,
because
because
the
of the
rates
rate.
for the older worker
Wow. See, I didn't
were much, much higher than for
huh.
the younger worker. Yeah, yeah.
So it's
I
not
mean, you
like
know, and so I
huh,
provided it, and that was the way it was. But I realized as soon as I saw the different rates depending on, they were age rated.
interesting.
And you realize immediately, like, that is a big disincentive to hiring an older worker who needs health insurance coverage. Yeah,
Wow,
it
which is
can be.
really bad.
Yeah, it is bad. It is
Yeah,
bad. Yeah, yeah. But
interesting. Huh.
benefits, employee benefits, we could do a
Oh, yeah,
whole
and
show on
that's
employee benefits
certainly not mine. Yeah,
because they're important, they're necessary, you know, to be offered, to be competitive, but it's a big expense for a small business.
it
Yeah.
is. I've thought for a long time, this is my own, like, my own Katherine Taylor world, that there really needs to be a middle road type of classification. I mean, let's take Uber. You know, Uber's been dinged in several states because, you know, they've been required to classify their drivers as employees.
Yeah.
Um, but, you know, but there, you know, and granted, I mean, if that's your full-time job and you're, you know, driving for Uber all day long, you know, 5, 6 days a week, then, you know, that's one thing. But there are a lot of people who just like to pick up the gigs, you know, kind of here and there. And so
Right.
to me, there really needs to be this middle classification. You know, maybe you're not completely an independent contractor where you've got your own consulting business, but you're not an employee. And I don't know, you know, if there was some kind of middle of the road classification, it might help both workers and employers.
Exactly. Exactly. Yeah. So on the 1099 side, as a business owner, other than, I know at the end of the year we send out our 1099s.
Right.
Other than that, are there any other responsibilities I have towards a 1099 contractor?
Not really. I mean, excuse me, you have to have a safe workplace, right? I mean, but most independent contractors are not going to necessarily be, well, some will, but not in your workplace, excuse me, physically. You did mention remote workers.
I wanted to ask about that. Yes.
Some
Yes.
people think that just because they're remote means they're an independent contractor and not an employee. And that is not the case. You know, it really depends on what they're doing. You know, probably 10 years ago, a remote worker was much more likely to be an independent contractor, primarily because there weren't that many and probably because they really were very independent. But now we've got full-time employees that are working their jobs, sitting at in their homes.
Sure.
And just because they're not at the employer's place of business doesn't mean that they're not an employee, or if they otherwise would be.
If the pandemic hasn't taught us anything, it should have taught us that, right?
Yeah, exactly.
But that's a really good point.
Right.
Wow, this has been wonderful. You're a wealth of information, Katherine, about this and all other things small business.
A wealth of information just to have this big question mark in your mind, like, oh my God. You know?
So listen, if listeners want to get in touch with you, how can they do that?
The best place, go to my website, taylorlegal.com, and you'll see our phone number.
Okay.
And you'll be able to submit an inquiry right there.
Okay. Let me post that so everybody can see it. Okay. There we go.
Perfect.
Got it up. There we go. Yeah, sometimes my expertise with technology gets a little funky. So, but we got it up there. So good. So, Katherine, any words of advice, last words of advice for small law firm owners and solo law firm owners about employees versus 1099 independent contractors?
Yeah, so I would say, look at all the factors, and in most of the time, what I suggest to my clients is, be cautious. It's better in this circumstance not to walk that line. You don't want to get too close to falling over. And yes, it costs more, but in the long run, you'll be better off, I think.
Yeah. And if they're in doubt, they can call you, right?
Absolutely.
Consult with Katherine. She'll figure it out for you. All right. Well, listen, thank you. Thank you for coming on. I really appreciate it. It was so great having you here. And thank you to everybody for listening. And come back next week. We're usually on Tuesdays from 2 to 3, but we did a special event today with Katherine. So we were on a different day and time. And it'll be different next week, too, because I'm out of town Tuesday afternoon. But hopefully Tuesday morning, I'll be able to get a LinkedIn Live up, and we'll take it from there. All right.
Thank you.
Thanks. Have a great day.